When you have children, the estate planning process becomes especially important. Not only is it necessary to ensure your wishes are carried out and your family is financially provided for if you pass, but it's absolutely vital for the purpose of naming a guardian who will raise your children if you and the other parent are ever killed or unable to raise them. The fact is, accidents happen all the time, and the potential for a life-changing event that would leave your minor children without parents to raise them and care for them is high. If such a worst-case scenario were to occur, wouldn't you rather make the determination of who should raise your children instead of having it up to a court and a judge who does not really know your kids or what you would want? But the seriousness and gravity of naming a guardian can sometimes leave parents overwhelmed. Moreover, there are some who just don't take this seriousness enough. Here, I want to share with you 5 common mistakes that parents need to avoid when naming a potential guardian for their children. Number 1, choosing someone because you're expected to. People often assume that they need to choose obvious people as guardians, maybe their parents or their siblings. But these people may not always be the best choice to raise your children. Never name a guardian to appease someone or avoid hurting their feelings. Never name someone as guardian because you think you're expected to. Your children's futures are at stake. And quite simply, you need to make the best choice, not the expected choice. Number 2, making an emotional decision. Selecting a guardian should be logical, and you have to remove emotion. For example, maybe you don't personally get along with your spouse's sibling, but logically, that person would be the best for your kids. And if you were unable to do it, they would be the ones. Try to remove emotion and think logically about the best interest of your children. Number 3, select someone that a court wouldn't allow. There are certain occasions in which a court may not honor your choice as a guardian, such as if the party has a drug or alcohol issue or a significant criminal history. Selecting someone a court would likely question or disallow would really complicate the process, make things harder for your kids, and in effect, result in the same situation as if you never named anyone at all. Number 4, naming someone without resources. You may have a great guardian in mind who will love and care for your kids and raise them with the values that you envision. But if they don't have the financial resources to care for and provide for them, they probably should not be your choice. This is especially important if you have more than one child and you want to ensure that your kids stay together. Raising a child is a serious financial burden, and your guardian should be able to shoulder such a burden. Number 5, naming someone who won't be around. Imagine if you name someone as a guardian for your minor children who are significantly advanced in age or poor health. Your kids are faced with the trauma of losing their parents and going to live with their guardian. Then, within several years, your kids are faced with the additional trauma of losing that guardian. It's important to name someone as a guardian whom you expect to be around for a significant amount of time. No one can predict the future, I know, but naming an elderly parent as a guardian may not be a better choice than naming a middle-aged guardian if all the factors were the same. The importance of naming a legal guardian who will raise your children if you and your spouse are killed or incapacitated cannot be overstated. Nothing less than your children's future and well-being are at stake. Please take immediate action to begin the estate planning process, including naming a guardian. The Mattis Law Group can help. Give us a call today to get started by clicking below for an appointment with our team, and we'd be so happy to talk to you and your family and do what we can to help.